I speak 32 languages.
Oh, sure, and I'm an astronaut.
The orange is the first thing people see, before the face, before the eyes, before any expression that might communicate who a person actually is. The orange announces everything the system has already decided. It says, this person has been processed. This person has been reduced. This person is here because we put her here, and she will remain here for exactly as long as we choose. She stood at the defendant's podium in Courtroom 7 of the Calhoun County Federal Building in Augusta, Georgia, with her wrists locked together in front of her body by a pair of standard-issue steel handcuffs that caught the fluorescent light every time she shifted her weight. She was 26 years old. She was 5 feet 4 inches tall. Her brown hair was pulled back in a simple knot at the base of her neck. Not styled, not arranged, just gathered and secured, the way you do it when you have other things to think about. She wore the orange detention uniform the way some people wear a borrowed coat. Technically, without ownership, as if the garment had nothing to do with her actual identity and she was simply waiting for the moment she could hand it back. Her name was Nora Voss. And in that courtroom on that February morning, she was invisible in the specific way that people in orange jumpsuits are always invisible. Seen by everyone, perceived by no one, the gallery behind her held approximately 30 people. Law students from Augusta State, sitting in the back rows with notebooks and the specific alertness of those who believe they are witnessing something educational. A few journalists from the regional press corps, notebooks open, covering what had been filed in court documents as a straightforward fraud case. A woman in the third row, early 50s, wearing a blazer that had been ironed too many times, who had not written anything in her notebook since she arrived, and who was watching the room with the careful attention of someone paid to do exactly that. None of them knew what was about to happen, including, for just a few more minutes, the judge. Judge Raymond Carver, 63 years old, 26 years on the federal bench, a man who had been appointed during an administration that valued loyalty above most other judicial qualities and who had, over a quarter century, developed the specific confidence of someone whose authority has never been seriously challenged. Sat behind the elevated oak bench, with the ease of someone in a piece of furniture they have occupied for so long it has taken the shape of them. He was a large man, broad across the shoulders, with silver hair parted and combed in the manner of men from a certain generation who understood grooming as a form of professional communication. He wore reading glasses on the end of his nose. He was holding a document, and he was smiling. Not the professional neutral expression that judicial training is supposed to produce. Not the careful composure of someone aware of being watched. He was smiling the way a man smiles when he is about to do something he has done before, something he has always been permitted to do, something that has never cost him anything. He cleared his throat. He began to read in German. The sound of it filled the courtroom, the way unexpected sounds fill formal spaces, with a kind of wrongness that the room's architecture amplified rather than absorbed. It was not fluent German. It was the German of someone who had spent enough time with the language to perform competence without achieving it. The pronunciation approximate, the rhythm slightly off but deliberate. Intentional. He was not confused. He was not reading the wrong document by accident. He was making a choice, and the smile on his face while he made it said everything about what that choice was for. In the gallery, someone suppressed a laugh. One of the law students in the back row leaned toward another and whispered something. A journalist wrote a single word in her notebook and underlined it twice. Nora Voss did not move. She stood at the podium with her cuffed hands folded in front of her and her gaze fixed on a point approximately 3 feet above the judge's head, and she did not react to the German in any visible way. Not confusion, not distress, not the searching, lost expression of someone hearing sounds they cannot decode. Her face was the face of someone who was listening very carefully to something, processing it in real time, and choosing deliberately, strategically, to reveal nothing yet. But they didn't know that. No one in Courtroom 7 knew that, and that was exactly the way Nora Voss had intended it. To understand what happened in Courtroom 7 that morning, you have to go back 14 years. You have to go back to a small house in Savannah, Georgia, where a woman named Elise Voss worked the overnight shift at a hotel laundry facility and came home every morning at 6:45 smelling of detergent and institutional linen, where she would find her daughter already awake, already at the kitchen table, already reading, always reading. Elise had raised Nora alone from the time Nora was 4 years old, in the specific and exhausting way of single mothers who understand that they are building something with no margin for structural error. She worked 2 jobs for most of Nora's childhood: the laundry facility overnight and a weekend shift at a grocery store 2 miles from the house that she reached by bus, because the car had stopped being reliable in 2011 and had stopped being a car entirely by 2012. She did not complain about this. She noted it, she made the adjustments it required, and she moved forward, because moving forward was the only direction that led anywhere. What Elise Voss could not have explained, even if someone had asked her, was why her daughter was the way she was. Nora had started reading at 3. Not the staged, guided reading of a child, being prompted through letter recognition, actual reading, unprompted, picking up a magazine her mother had left on the coffee table and working through the text with the focused absorption of someone for whom the process required no instruction. By 5, she was reading chapter books. By 7, she had exhausted the children's section of the public library 2 blocks from their house and had begun, quietly, without asking permission, in the way children do things they sense will require negotiation, reading in the adult sections. But the reading was only the surface of it. What Nora had, underneath the reading, was something rarer and more specific. She heard language, not just the words, but the architecture beneath them. The patterns, the logic of how sounds mapped to meaning, how meaning shifted across context, how the same structure could carry completely different weight, depending on the mouth that produced it and the room in which it landed. She heard all of this the way some people hear music, not as individual notes, but as structure, as relationship, as a system that made an internal kind of sense that she could not entirely articulate, but that she could feel with the precision of someone reading a floor plan. At 8 years old, Nora Voss was learning Spanish from the family 2 houses down. A grandmother named Señora Reyes, who had come from Oaxaca in 1989, and who taught Nora vocabulary over the back fence, while they both hung laundry on Saturday mornings, delighted by a child who not only remembered every word, but came back the following week, asking about the phonological difference between the Spanish spoken in her village and the Spanish she heard on television. At 10, she had added French, learned in 12 weeks from library books, and a cassette tape course meant for adult business travelers that she had found in a box of donated items at the church thrift sale. At 12, she was corresponding, in Italian, which she had taught herself from a grammar book and a battered copy of a cookbook she found at a school book fair, with a retired professor of linguistics at the University of Bologna who had discovered her through an online language learning forum and who had written, in the first message he sent to Elise Voss, that he had taught language acquisition for 38 years and had never encountered anything in a child that resembled what he was reading in her posts. At 14, Nora Voss spoke 8 languages. By 16, 11. By the time she graduated from high school, on a full scholarship to the Georgia Institute of Technology that her school counselor had actively discouraged her from applying for, citing the competitive field and what the counselor had described in a parent-teacher conference that Elise had attended in her work uniform because there had been no time to change, as unrealistic expectations for someone from Nora's background. The count was 14. Elise Voss had attended that parent-teacher conference, had listened to the counselor explain her daughter's limitations, had nodded in the way that women who work overnight shifts learn to nod when people in positions of institutional authority explain the ceiling above them, and had gone home and told Nora to apply to every school on the list. Nora applied to 11. She was accepted by 9. She chose Georgia Tech because it offered the strongest computational linguistics program, and because the scholarship covered room and board, and because she had calculated with the specific financial precision of someone who has grown up watching money get counted very carefully, that it would leave Elise with the least additional burden. She never told her mother about the other 8 acceptances. Georgia Tech was where the count accelerated. Not because the university offered resources Nora hadn't had before, though it did, but because being surrounded for the first time by people who took language seriously as a field of study, as a technical problem, as a structure worth dismantling and rebuilding from the inside, gave her permission to stop hiding the speed at which she moved. She completed her undergraduate degree in 3 years, computational linguistics, with a concentration in forensic language analysis, the study of language as evidence, language as the carrier of identity and intent, language as the thing that cannot be fully disguised, no matter how carefully the speaker believes they have disguised it. She was 20 when she graduated. She was working on her master's thesis at 21. The thesis was about coerced confessions, specifically about the linguistic markers, the syntactic anomalies, the register inconsistencies, the vocabulary mismatches that appear in statements produced by people who are under extreme psychological pressure and who are being guided, consciously or not, toward producing language that serves the needs of an investigator rather than the truth of what actually happened. She had started the research after reading, in a criminal justice journal she had found in the university library, about a case in which a 19-year-old had confessed to a murder he had not committed and served 11 years before DNA evidence cleared him. The confession transcript had been included as an appendix. Nora had read it once, and then she had read it again, and then she had sat very still for a long time, because what she saw in that transcript was not guilt. It was the specific linguistic signature of a person producing language that someone else had shaped. She could see it the way a trained radiologist sees a fracture in an X-ray, not as an obvious crack, but as a shadow, an irregularity, a disruption in the expected pattern that meant something specific to someone who knew what they were looking at. She completed the master's degree at 22, with a thesis that her committee described as the most technically rigorous work they had seen from a graduate student in a decade. She was accepted into the doctoral program. She was teaching undergraduate courses in forensic linguistics by 23, and she was, by 24, consulting, quietly, under confidentiality agreements because the field was sensitive and the organizations involved were careful, for 3 federal public defender offices that had started using computational linguistic analysis as part of their case preparation in complex fraud and coercion cases. 24 languages by her 25th birthday. The last 2 had been Mandarin and modern Arabic, both learned in parallel over 18 months because she had identified them as the 2 most structurally demanding systems she had not yet mapped, and she had wanted to understand what it felt like to acquire a tonal language and a root-based morphological system simultaneously, for purely analytical reasons that she had written up as a research note and submitted to a journal that had published it 4 months later. No one at Georgia Tech had known about the consulting work. No one in the federal public defender system had known about the doctoral research. That was intentional. She had learned by 25 that the safest version of competence is the one that no one has been given time to be threatened by before it becomes necessary. What no one in Courtroom 7 that morning knew, not the judge, not the prosecutor, not the journalists in the gallery with their open notebooks, was how Nora Voss had arrived at that podium in an orange jumpsuit with her wrists in handcuffs. It had not started with a crime. It had started with a pattern. 18 months earlier, Nora had been brought in by a federal public defender named Carol Hutchins to consult on a fraud case in which the defendant, a 67-year-old former accountant named Arthur Poole, who had been a client of the firm that bore the name Whitfield, Carver and Associates, had been charged with embezzling from a series of investment accounts he managed for elderly clients. The case had initially appeared straightforward. There were transaction records, there were account discrepancies, there was a defendant who had limited financial resources for his own defense, and who, under questioning, had provided statements that seemed to confirm the prosecution's timeline. Nora had been hired to analyze the interview transcripts. She spent 6 days with them. On the 7th day, she called Carol Hutchins and said, in the measured and specific language she used when the stakes were high, "These statements were shaped. I can show you where and by how much and what the shaping was intended to produce. And there is something else in here that you need to see." The something else was a pattern that Nora had noticed first as a linguistic irregularity, a specific cluster of vocabulary choices that appeared in the prosecution's own internal documents. Documents that had been produced in discovery, that matched with a precision no random coincidence could explain the vocabulary of financial transaction descriptions that appeared in a separate set of documents that Arthur Poole had never had access to. It was the kind of pattern that only exists when someone has constructed a paper trail, and it was the kind of pattern that is essentially invisible unless you are reading the documents the way Nora read documents, not for content, but for linguistic fingerprint. Arthur Poole had not embezzled anything. Someone had embezzled on his behalf, in his name, using documents constructed to look like his work. And the construction was sophisticated enough that it had fooled a forensic accountant, a federal investigator, and an entire grand jury. It had not fooled Nora Voss. What happened next moved slowly and then very quickly, the way institutional responses to institutional failure tend to move. Resistance, denial, escalating pressure, and then, when the evidence passed a threshold that made denial untenable, a sudden and comprehensive attempt to control the narrative. The attempt to control the narrative had included, 4 months before the February hearing in Courtroom 7, the arrest of Nora Voss on charges of obstruction of justice, falsification of expert testimony, and conspiracy to commit fraud. The charges were constructed with the same sophistication as the documents that had been used to frame Arthur Poole. They referenced communications that had been selectively excerpted. They cited conclusions that had been attributed to Nora that she had never drawn, attached to analysis documents that had been altered after she had submitted them. The case against her was a linguistic construction, and the people who had built it had banked on the certainty that no one would be able to read the construction for what it was. They had been right about almost everyone. They had been wrong about Nora. Judge Raymond Carver had presided over Arthur Poole's trial. His name had been on the operating license of Whitfield, Carver and Associates until 2008, when he had formally divested, on paper, in advance of a federal nomination process that required the disclosure. The divestiture had been processed by a law firm whose senior partner was his brother-in-law. The financial arrangements that followed the divestiture were recorded in instruments that were technically legal and functionally a fiction, the kind of fiction that requires a specific kind of reading to see through. Nora had read through it in 11 days. She had not yet told her attorney everything she had found, not because she didn't trust Carol Hutchins. She did, completely. But because she had spent 6 months learning in the specific school of sitting in a detention facility in an orange jumpsuit. That timing is everything when the person you are facing controls the room and believes he controls all of the exits. She had been waiting for the right moment. And Judge Raymond Carver with his reading glasses and his broad shoulders and his smile, had just handed it to her. He finished the German passage and set the paper down with the particular satisfaction of a man who has made his point. The smile had not left his face. He looked at Nora over the top of his reading glasses with the expression of someone who has placed an object on a high shelf and is waiting to watch someone shorter fail to reach it. The gallery was quiet in the specific way that groups of people are quiet when they are collectively uncertain whether what they just witnessed was appropriate to laugh at. One of the law students in the back row had her pen raised above her notebook and had not written anything in 40 seconds. Carol Hutchins, seated at the defense table to Nora's left, had both hands flat on the table in front of her and was looking at her client with the expression of a woman who has spent 20 years in federal courtrooms and has just witnessed something that does not fit inside any category she has. Nora Voss looked at the judge. She let the silence hold for exactly 4 seconds. Then she said, in German, clean, unhurried, the German of the University of Vienna, the German of academic papers and federal legal proceedings, the German of someone who had spent 2 years living inside the language until it lived inside her, she said, Your Honor, if it would assist the court, I can respond to those passages directly. However, I should note for the record that the text you just read is Article 14 of the German Code of Criminal Procedure, which governs the rights of defendants in proceedings conducted before a language barrier exists, and which, under that same provision, requires that any defendant who demonstrates comprehension of the language being used is entitled to have that language formally recognized in the proceedings. She paused. I am demonstrating comprehension. The silence that followed was a different kind of silence than the one before it. The law student in the back row slowly lowered her pen. The journalist who had written one word and underlined it twice turned to a new page. And Judge Raymond Carver, 63 years old, 26 years on the federal bench, a man whose authority had been unchallenged for so long that challenge had become literally inconceivable to him, went entirely still. His smile did not fade. It simply stopped, like a light that has been switched off, leaving the room suddenly aware of how much it had been relying on artificial illumination. He stared at her. She looked back at him with the composed, direct attention of someone who has been waiting for this specific moment for a very long time and has spent that time preparing for exactly what comes next. In that exact moment, in that precise, documented, witnessed moment, everything changed. Not loudly, not dramatically, not with the flourish of courtroom television where music swells and observers gasp. Quietly, structurally, the way the most important changes always happen, the ground shifted. And everyone in the room felt it, even those who could not have explained what they were feeling or why. Who told you? Carver began. He stopped himself, composed his face into something more neutral, started again. The court notes that the defendant appears to have some familiarity with German. His voice had lost its earlier warmth. It was now the voice of someone managing a situation that had veered outside the prepared script. We will continue with the proceedings in English. Of course, Your Honor. Nora's voice was even, cooperative, the voice of someone choosing, very precisely, when to deploy each of the things they know. Though for the record, I'd also be comfortable continuing in French, Italian, Spanish, Mandarin, Arabic, Russian, Japanese, Portuguese, Dutch, Polish, Swedish, Turkish, Korean, Hindi, Greek, Hebrew, Romanian, Czech, Hungarian, Swahili, Thai, Vietnamese, or Farsi, whichever the court finds most useful. She listed them the way you recite facts. Not as performance, not with pride, the way a carpenter lists the tools in their workshop when someone questions whether they have what the job requires. 32 languages. 32. The journalist in the gallery turned to yet another page. Carol Hutchins, at the defense table, pressed both her hands harder into the wood surface and said nothing and let her client work. The woman in the third row with the blazer that had been ironed too many times, the one who had not written anything in her notebook since she arrived, wrote something now. 3 lines, quickly, and then she put the pen down and looked at Nora Voss with the specific expression of someone who has just confirmed something they already suspected. Her name was Margaret Osei. She was a senior investigator with the Department of Justice's Office of Professional Responsibility. She had been sitting in Courtroom 7 for the past 2 hours because 6 weeks ago she had received a packet of documents mailed from an address in Augusta with no return name that had contained 47 pages of financial and linguistic analysis with a cover note that read, in the cleanest and most precisely worded single paragraph she had encountered in 22 years of professional correspondence. I am going to need you to see this in person. It will become clear why written submission is insufficient. Please be in Courtroom 7 on February the 14th. She had been, and it was becoming very clear. Judge Carver called a recess. He did not explain the reason. He did not need to. Judges don't explain recesses, they declare them, and the declaration is its own justification. He rose from the bench. And his clerk rose, and the bailiff moved, and the room recalibrated around the fact of his exit with the practiced efficiency of a space that had been doing this for decades. He was on the phone before he reached the door of his chambers. Nora watched him go. Then she turned to Carol Hutchins. Carol looked at her for a long moment. She was 52 years old and had spent those years in federal courts and had thought she had developed a comprehensive catalogue of surprises. She was revising that assessment in real time. 32, Carol said. 32. You couldn't have led with that at any point in the past 14 months? He needed to underestimate me first, Nora said. If I walked into this room known, he would have found a different strategy. I needed him to use the one he was comfortable with. She glanced toward the door Carver had gone through. People who rely on making others feel small always reach for the same tool when they feel threatened. I needed him to reach for it in front of witnesses. Carol looked at the gallery, where the journalists were talking in low voices, and the law students were no longer taking notes in the manner of students. They were taking notes in the manner of people who have just watched something they will be telling other people about for the rest of their careers. What's in the folder? Carol asked quietly. Nora looked at the manila folder that sat on the defense table, plain, unadorned, the kind of folder sold in drugstores for $1.49. The reason, Nora said, that today is only the beginning. The recess lasted 31 minutes. Nora spent them at the defense table with the manila folder open in front of her, organizing documents in a specific sequence she had rehearsed in her head 400 times over the past 3 weeks. Not because she needed to rehearse it, because in high-stakes proceedings, the difference between prepared and over-prepared is the difference between a structure that holds under pressure and one that holds under everything. And Nora Voss had spent 14 months in circumstances that had taught her, with a thoroughness that no academic program could replicate, that the pressure was always higher than you anticipated. Carol Hutchins sat beside her and read through a subset of the documents for the 3rd time, making small notations in the margin with a mechanical pencil she had carried in the same blazer pocket for 11 years. She read the way lawyers read when they have moved past the stage of comprehension and into the stage of strategy, not absorbing what the document said, but modeling how they would land in the hands of the people who needed to receive them. You sent this to the DOJ, Carol said. It was not a question, not a 6 weeks ago. Without telling me. You would have needed to disclose it. The timing would have been wrong. Carol set down the pencil. She looked at Nora with the expression of a woman who is simultaneously exasperated and impressed, the specific emotional cocktail of a professional who has just been outmaneuvered by her own client in a direction that happens to be correct. "The woman in the third row," Carol said. "Blazer, not writing anything until the German. Margaret Osei, DOJ Office of Professional Responsibility." Nora said it the way she said most things, as information precisely delivered. "She confirmed receipt of the packet 4 weeks ago. She said she would be here. She is." Carol looked at the folder, then at the ceiling, then back at Nora. "Walk me through what we're about to do." "We are going to give Judge Carver one opportunity to demonstrate voluntary transparency," Nora said. "When he declines that opportunity, and he will decline it, because men who have operated for 26 years without consequence are constitutionally incapable of recognizing the moment when transparency has become their only viable option. The documentation will be entered into the record, all of it, and Margaret Osei will have everything she needs for a formal referral." "And if he does demonstrate transparency?" Nora looked at the door of the chambers. "He won't. He didn't. When Judge Carver returned from his chambers, he returned with a different energy, the contained, slightly overcomposed energy of a man who has made calls, received information, and decided on a strategy that involves projecting control so forcefully that the room accepts the projection as the reality." He settled into the bench. He adjusted his glasses. He picked up the proceedings schedule and studied it for a moment longer than was necessary. "We'll continue," he said, in a voice calibrated to suggest that nothing unusual had occurred and that he had simply taken a few minutes to attend to administrative matters. "The court is prepared to address the defense's motion to dismiss on the grounds of—" "Your Honor." Carol Hutchins was on her feet. He looked at her with the mild displeasure of someone who has already mapped the remainder of the morning and is being asked to deviate. "The defense has additional materials it wishes to submit to the record, with the court's permission. Counselor Hutchins, if you're referring to the supplemental forensic materials already—" "Different materials, Your Honor, submitted under Rule 16 of the Federal Rules of Criminal Procedure. Specifically the provision covering expert analysis documentation. The defendant has been identified as a forensic linguistic analyst operating under professional certification, and the materials relate directly to the charges and to the broader context of this proceeding." A pause. "What materials? What specifically?" Carol looked at Nora. Nora stood up. She stood up in her orange jumpsuit with her handcuffed wrists in front of her, and she looked at Judge Raymond Carver the way you look at something you have been studying for a very long time and now understand completely. And she said, "Your Honor, I'd like to submit for the record a comparative linguistic analysis of 47 documents produced by the prosecution in this matter, cross-referenced with documents produced in the original prosecution of Arthur Poole in this court, and further cross-referenced with internal communications produced in discovery from Whitfield Capital Partners, LLC." She paused. "The analysis demonstrates with a statistical confidence of 93.8% that 14 of those documents share linguistic fingerprint markers, specifically lexical selection patterns, syntactic preference structures, and idiosyncratic punctuation habits, with documents authored by a single writer, a writer whose identity is established by 3 independent corroborating sources, all of which are included in the submission." Carver had gone still again, the same stillness as before, but this stillness was different. It had more information in it. It was the stillness of a man who had just heard something specific and was calculating, at high speed, what the specific thing implied. "The writer," Nora continued with the even, unhurried delivery of someone reading from a map they have memorized, "is not Arthur Poole. The linguistic evidence establishes this with a degree of certainty that exceeds the threshold required for expert testimony under Daubert. It also identifies the actual author. That identification is supported by financial records, communication metadata, and a series of real estate instruments whose unusual structure becomes clear when read in conjunction with the judicial recusal disclosures filed between 2008 and 2012. She let that land. Then she said, "I can submit these materials now, Your Honor, or the court can review them in camera, but they will be submitted. They are also currently in the possession of a representative of the Department of Justice's Office of Professional Responsibility who is present in this courtroom." Every head in the gallery turned toward the third row. Margaret Osey did not change her expression. She held Carver's gaze for exactly the amount of time required to communicate that yes, she was there, and yes, she had what Nora had said she had, and yes, she understood what it meant. Carver looked at Nora. He was 63 years old and had been a federal judge for 26 years, and he had sat on that bench through testimony from Nobel laureates and career criminals and expert witnesses who were the foremost authorities in their fields. He had heard language used as every instrument available to a human being, as scalpel, as blunt weapon, as camouflage, as revelation. He had heard people lie to him, and he had heard people tell the truth, and he had heard the thing that exists between them that most people cannot identify, but that a trained ear recognizes as the third option. Someone saying something they know is true and intend to be true, but which they are also deploying as a weapon, strategically with precision. He was hearing that now. He looked at the folder on the defense table. He took a long breath. And then he said something that nobody in that courtroom had heard him say in 26 years, or in any room, in any language, in any context that any of the people present could recall. "The court will take a 30-minute recess to review the submitted materials before proceeding." It was not an admission. It was not a concession. It was the first retreat of a man who had spent a career making sure he was never in a position where retreat was the least bad option, and who was now in exactly that position, and who understood it. The room understood it too. What happened in the following 8 weeks moved through the federal system with the specific momentum of something that has been compressed for a long time and released all at once. The materials Nora submitted that morning comprised 62 pages of forensic linguistic analysis, 39 pages of financial documentation, and 8 pages of communication metadata, all of it assembled during the 14 months she had spent in pre-trial detention, doing the only thing she could do, which was the thing she had always done: reading, working, mapping, preparing. She had been given access to a prison law library. Standard pretrial procedure. She had requested through Carol Hutchins access to the discovery documents from her own case and from the Poole case. Standard defense preparation. She had read every page. She had found what she found. She had built what she built in a 6x8 cell with a 30-minute daily computer access window, with no research database, no academic library, no laboratory, just the documents and her training, and the 14 years of discipline that had started at a kitchen table in Savannah with a 3-year-old who was already reading. The Department of Justice opened a formal investigation into Judge Raymond Carver on March the 2nd, 47 days after the February hearing. The investigation covered potential violations of 18 U.S.C. Section 15 in relation to financial conflicts of interest, potential violations of 28 U.S.C. Section 455 regarding mandatory judicial disqualification, and a broader pattern of conduct in case assignments and rulings that was described in the official opening document as suggesting a systematic relationship between judicial outcomes and the financial interests of associated parties. The language was careful. It was federal government language. the language of institutions protecting themselves, even as they investigated themselves. But even through the careful language, the shape of what had been found was visible. Arthur Poole's conviction was vacated on March the 14th. He was 68 years old by then. He had served 9 months of a 4-year sentence. He walked out of the Calhoun County Federal Correctional Facility on a Thursday morning into the arms of his daughter and her 2 children, who had driven from Charlotte, and the photographs that appeared in the Augusta Chronicle that afternoon showed a man who looked older than he should have looked, and who was holding his granddaughter as if he was not certain she was real. The charges against Nora Voss were formally withdrawn on March 22nd. The prosecutor who had brought them, a man named Stephen Aldrich, who had been with the U.S. Attorney's Office for 9 years, was placed on administrative leave pending the investigation's review of his office's conduct in both cases. He resigned 4 weeks later. His resignation letter, made public per departmental policy, was 3 sentences long and contained no statement of wrongdoing and no explanation. Nora read it in a coffee shop in Augusta on a Wednesday afternoon, the first Wednesday after her release, and noted that even the resignation letter bore the specific syntactic signature she had identified as characteristic of a man who had learned to communicate in the register of plausible deniability. She made a note of it, not for any proceeding, for her research. Raymond Carver retired from the federal bench on April the 3rd, citing health concerns in a statement released through his personal attorney. The statement was 4 paragraphs long. Nora read it once. The health concerns were not specified. The Office of Professional Responsibilities investigation was ongoing as of its last published update. Federal judicial investigations move at the speed of federal judicial investigations, which is to say, deliberately, methodically, and on a timeline that is calibrated to the weight of evidence and the institutional stakes rather than to the human urgency of the people waiting for the outcome. There are people who find this maddening. Nora found it acceptable. She understood that the machinery of accountability, when it genuinely engages, requires time to produce output that holds. Rushed machinery produces rushed results. She had seen enough rushed results in her 14 months of reading case files to understand the cost of them. She was also 26 years old. She had time. She did not give interviews. She had been asked for 17 by the time she stopped counting, from outlets ranging from a local Augusta weekly to 2 national magazines to a documentary filmmaker whose work she had seen and respected. She declined each one with a brief and courteous note written in English, though she was sometimes tempted, purely as an exercise, to decline in one of the other 31 languages and see who noticed. The one exception was a conversation with Margaret Osei, which happened not as a formal interview, but as something closer to a debrief, 2 professionals sitting in a conference room in the Atlanta DOJ field office, working through the details of what had happened and what it meant. At the end of that conversation, Margaret had asked, "The German in the courtroom, did you know he was going to do that?" "I knew he was the kind of man who would do something like that," Nora said. "I prepared for several versions. That was the one he chose." "Why German specifically, do you think?" Nora thought about this for a moment. Not because she didn't know the answer, she had known it since the morning in the courtroom, but because she wanted to find the version of it that was truest rather than just most convenient. German has a particular reputation in American institutional imagination, she said finally. It sounds authoritative, official, inaccessible. He chose it because it sounded like the ultimate version of language as power, the language of bureaucracy and legal systems that a young woman in an orange jumpsuit from a modest background in Savannah, Georgia, would have no possible connection to. She paused. He was trying to demonstrate in one gesture everything he believed about the difference between her and him. Margaret nodded slowly. "And your response?" "I gave him the accurate version of the gesture." Nora said it simply, without satisfaction, without heat. He used language to try to make me smaller. I used language to show him, and everyone watching, exactly how large the space between what he assumed and what was actually true had always been. Margaret wrote something in her notebook. Then she looked up. 32 languages, she said. Is there a 33rd in progress? Nora smiled. It was a small smile, genuine, the first fully unguarded expression she had permitted herself in a very long time. There's always a 33rd in progress, she said. Arthur Poole came to see her once, in the weeks after both their releases. He was 68 years old and moved carefully, with the physical caution of someone whose body had been through something significant, and he sat across from Nora in a coffee shop near the Georgia Tech campus. She had gone back, quietly, to finish her doctorate, and he folded both his hands on the table and looked at her for a moment without speaking. Then he said, "I don't know how to thank you." Nora looked at him. She thought about the 11 years that an earlier man, the 19-year-old whose coerced confession transcript she had read in a journal article at 21, had lost. She thought about the 9 months Arthur Poole had served. She thought about the cost of systems that have no mechanism for their own error until someone external provides one. "You don't need to thank me," she said. "What happened to you shouldn't have been possible. The fact that it was possible means there was a problem in the structure. I fixed one instance of the problem. The structure still needs more work." Poole nodded slowly. He was quiet for a moment. "My granddaughter," he said, "is 7 years old. She wants to be a scientist. My daughter wasn't sure about the school district, whether it was worth, the resources, the competition." He looked at his hands. "I told her to let the girl try, to not decide what she can handle before she's had the chance to show you." Nora looked out the window at the Georgia Tech campus, the buildings she had moved through at 17 with 2 bags and a full scholarship, and a school counselor's voice in her head explaining the ceiling above her. "That's the right advice," she said. The thing that never made it into any of the reporting was what happened on the morning of her release. Carol Hutchins had been there with a change of clothes, civilian clothes, because the first thing you do when a system hands you back your identity is put it back on. And the 2 women had walked out of the Calhoun County facility in the early morning light. The specific grey-blue light of a February morning in Augusta that is cold and flat and honest, and had stood for a moment in the parking lot before getting into Carol's car. Carol had asked, "What do you need? Food, sleep, a phone call. What?" Nora had said, "I need a library." Carol had blinked. "Right now? There's a paper I've been working on for 14 months. Nora said. "I need proper access to finish it." Carol drove her to the Georgia Tech Library. It opened at 7:30. Nora was at a research terminal at 7:32, in the civilian clothes that were slightly too large because she had lost weight. With her faculty credentials reinstated that morning through a process Carol had set in motion 3 weeks earlier. She was working on the 33rd language. Not from vengeance, not from a need to prove something, from the same reason she had learned every language before it, because a system that produces injustice does so partly through the walls it builds around knowledge. And every wall has a language, and every language learned becomes one more wall that cannot be used against you or the people you are trying to reach. She pulled up the research database. She opened the draft paper. She read the last paragraph she had written 4 months ago in the prison law library, on a 15-minute computer window that had timed out before she could finish the sentence. She finished the sentence, and then she kept going. Elise Voss drove up from Savannah that afternoon. She arrived at the Georgia Tech Library at 2:45 and found her daughter exactly where Carol Hutchins had said she would be, at a terminal in the third-floor linguistics section, surrounded by printed articles and handwritten notes, deeply absorbed in something that Elise could not follow, but that she recognized, the way you recognize something you watched being built from the very first stone, as the specific expression her daughter made when a problem was yielding to her. Elise sat down in the chair next to her and waited. After a few minutes, Nora looked up. They looked at each other. Elise was 51 years old and had worked a night shift at a hotel laundry facility the previous evening because that was Tuesday, and Tuesday was a shift day, and she was not the kind of woman who called in because something important had happened. Because important things had been happening her entire life and the work still needed doing. "Hi, Mom," Nora said. "You look thin," Elise said. "I'm okay." "I know you are." Elise looked at the screen, at the pages, at the printouts. "What are you working on?" "A paper," Nora said, "and a language." "Which language?" "Amharic." "Ethiopian." Nora turned back to the screen for a moment, then back to her mother. "There's a community in Atlanta, recent immigrants, asylum cases. The interpreters available to them are inadequate. The legal outcomes are being affected. I've been reading the case files." Elise looked at her daughter. Nora was 26 years old, and she was sitting in a university library in civilian clothes that were slightly too large, and she had a 14-month gap in her academic record that was going to require explanation in every application she ever submitted for the rest of her life, and she had 32 languages and was learning a 33rd. And she had just survived, methodically, deliberately, with the patient precision of someone who knew exactly what they were doing, an attempt by a federal judge to destroy her in order to protect himself. Elise Voss had worked overnight shifts and weekend shifts and double shifts and every combination of shifts available to a woman, determined to make sure her daughter had what she needed. She had listened to a school counselor explain her daughter's ceiling. She had nodded in the way you learn to nod. She had gone home and said, "Apply to every school on the list." She reached over and covered Nora's hand with hers for a moment. "Show me the case files," she said. Raymond Carver's formal investigation was still ongoing when this account was written. The outcome of institutional investigations is never certain, and the space between what is documented and what is adjudicated is where systems most often protect themselves. What is certain is this: 62 pages of forensic linguistic analysis assembled by a 26-year-old woman in a 6-by-8 cell with 30-minute daily computer access had set in motion a process that involved the Department of Justice, the federal court oversight system, the vacated conviction of an innocent man, and the retirement of a federal judge who had smiled while reading German to someone he was sure could not understand it. He had been sure, he had been wrong. And the lesson of that wrongness, the specific, structural, replicable lesson, was not about 32 languages, though the 32 languages mattered. It was about what happens when a system built on the assumption of certain people's limitations encounters someone who has spent their entire life preparing for exactly that assumption and turning it, with patience and precision and complete absence of self-pity, into the foundation of everything they do. You cannot mock what you have not taken the time to understand, and you cannot silence a language you do not know exists. 6 months after her release, Nora Voss submitted her doctoral dissertation to the Georgia Tech Graduate Committee. It was 312 pages long. The title was Linguistic Coercion and Systemic Failure: A Forensic Analysis of False Confession Patterns in Federal Criminal Proceedings, 2010 to 2023. The committee approved it with distinction and no revisions requested. The first time that outcome had occurred in the department's history for a dissertation submitted by someone who had completed the final third of the research in a pretrial detention facility. The dissertation contained, as Chapter 9, a detailed case study of the Arthur Poole proceedings, rendered in anonymized but fully traceable form that any legal professional reading carefully would be able to identify. It also contained, as an appendix, the complete forensic methodology Nora had developed over 14 months. The system of linguistic fingerprinting, the statistical threshold models, the cross-referencing protocols, documented with the precision of something designed to be replicated. Designed, specifically, to be used by other people in other cases who did not have 32 languages and 14 months in a law library, but who did have access to a methodology that worked. She published it openly, without restriction, under a Creative Commons license that allowed any public defender, any legal aid organization, any non-profit working with wrongful conviction cases to use it freely. Within 8 months of publication, she had received correspondence from attorneys in 11 states and 3 countries who had applied the methodology to their own cases. 4 of those applications had produced evidentiary findings that were currently being reviewed. 2 had already contributed to successful motions for case reconsideration. She tracked all of this in a spreadsheet. Not for publication, not for grant reporting, not for any external audience, because the numbers represented people, and the people deserved to be counted. The Amharic took her 13 months to reach working proficiency, which was slower than any language she had acquired since the first few, and she found that she minded the slowness less than she had expected. Amharic was a Semitic language with its own script. Ge'ez, one of the oldest writing systems still in continuous use, and learning it required her to rebuild her relationship with written language at the most fundamental level, to start again from the shapes that carried sound before the sounds carried meaning. There was something clarifying about this, something that reminded her of what language actually was. Not a tool you mastered, but a world you entered, and the entering changed you in ways you did not always anticipate. The Atlanta asylum cases had been more complex than she had initially assessed. There were 41 families involved, across 3 case clusters, all represented by an underfunded legal aid organization whose sole staff attorney was doing the work of 7 people and had approximately the same number of hours in a day as everyone else. Nora volunteered 3 days a week. She worked with interpreters who were available and trained the ones who were not. She reviewed translated documents and produced corrected versions when the originals were inadequate, not as the primary attorney, not in any official legal capacity, because her credentials in that area had specific boundaries and she respected them, but as an expert in the only thing she claimed expertise in, what the language actually said, and whether the version in the official record matched it. In 2 of the 41 cases, it did not match in ways that proved consequential. In one of those cases, the original translation had converted a statement about political retaliation into a statement about personal dispute, a difference of 4 words in Amharic that had collapsed a viable asylum claim into one that appeared unfounded. Corrected, submitted with Nora's analysis and the supervising attorney's formal motion, the claim was approved on second review. The family, a mother and 2 daughters, aged 9 and 11, had been in the United States for 31 months by the time the approval came. The mother, whose name was Hiwot, had worked 2 jobs for those 31 months, in conditions that reminded Nora, with a precision that felt personal, of a woman in Savannah who had come home smelling of detergent at 6:45 every morning for most of her childhood. Nora did not tell Hiwot this. Some things are not comparisons to be made aloud. But she carried it. On a Thursday evening in November, Nora was working late in the linguistics lab, a small, cluttered room on the 4th floor of the building she had been navigating since she was 17 years old, when Carol Hutchins called. "I want you to know something," Carol said, without preamble, which was her way. "The Carver investigation concluded preliminary findings today. I got a brief from the Oversight Committee. The findings are being referred for formal disciplinary action. It's going to be a long process. You know how long these things take, but it's moving, Nora was quiet for a moment. And Arthur Poole's civil suit? Motion for summary judgment on damages was accepted this week. It'll go to trial in the spring. The defendant's legal team has been requesting continuances for 5 months. The judge denied the most recent one this morning. Good, Nora said, and then, after a pause, thank you, Carol. You're thanking me, that's funny. There was a note in Carol's voice that was almost warmth. The specific warmth of a woman who has been practicing legal restraint for 20 years and lets it through in very small amounts. I spent 14 months trying to get you out of a situation you'd been put in entirely because you found something that inconvenient people didn't want found. All I did was file the papers correctly. That is not all you did, Nora said. No, Carol agreed, but it's the part I'm trained for. A pause. What are you working on? Nora looked at the screen in front of her. The Amharic grammar notes, the case files from the 3rd asylum cluster, which had a court date in January and which contained a translated document that she had been reading for 3 days and that was not yet yielding to her, not completely, not in the way she needed. The 33rd language, she said, and someone else's case. Carol made a sound that was not quite a laugh, but lived in that neighborhood. Of course you are, she said. Go home at some point, Nora. I will, Nora said. She did not for another 3 hours. What Nora Voss understood in the quiet of the 4th floor lab on that Thursday night, what she had understood, if she was honest, since the morning in Courtroom 7 when she had listed 32 languages and watched Raymond Carver's smile go out like a light, was something that is difficult to articulate without reducing it to a slogan, which it was not. It was a structural insight, the kind that comes from spending years thinking about language as architecture rather than ornament. Power, she had concluded, was not primarily physical. It was not primarily financial. It was, at its most fundamental level, linguistic. It lived in who controlled the definitions, who determined which version of events became the official record, who got to name things and have the naming stick, and who got translated, always in the direction that served the translator's purposes, into something they did not say and would not have chosen. The antidote to this was not counterpower, not volume, not aggression, not the simple inversion of who held the gavel and who stood in the orange jumpsuit. The antidote was comprehension, the patient, exhaustive, relentless acquisition of comprehension, more languages, better methodology, more rigorous analysis, more precisely documented evidence, until the gap between what was said and what was recorded, between what happened and what was officially claimed to have happened, became visible to anyone who looked. She could not close that gap for everyone. She was one person with 32 languages and a methodology and 3 days a week to give to an underfunded legal aid organization in Atlanta. The gap was enormous. The system was enormous. The number of Arthur Pooles and Hewatts and people whose cases had never been read by anyone equipped to read them correctly was enormous. But the methodology was published. The dissertation was open access. The cases it had already touched were generating their own momentum. And she had 13 months of Amharic and a court date in January, and a case that was not yet yielding, but that would yield. Because they always yielded eventually, if you sat with them long enough and asked the language the right questions. She turned back to the screen. Outside the 4th floor window of the Georgia Tech Linguistics building, Atlanta was doing what Atlanta did on November evenings, sprawling, glittering, indifferent, full of millions of people in millions of circumstances, some of them in courtrooms, some of them in detention facilities, some of them in kitchens at 6:45 in the morning, smelling of work and determination and the particular kind of love that does not announce itself. She read the next page of the case file. She found what she was looking for on page 37. She started writing. Stories like this happen in federal courtrooms across America every week, visible only to the people inside them, documented only when someone with the tools and the patience decides to do the documenting. If this story moved you, share it, Because silence has always been the first language of injustice, and the only way to answer it is to speak, in whatever language it takes. Subscribe for more stories the headlines miss.